Washington Legal Foundation's webinar. My name is Glenn Lammi. I am the Executive Director and Head of the Legal Studies Division here at the Foundation. For those of you not familiar with the Foundation, we are in our 48th year of legal policy, advocacy, education, and litigation on a pretty wide range of issues that affect the free enterprise system, the rule of law, and individual and economic liberties. Pleased to have you here, spending your hour of time of your busy day. As you may know, WLF is one of the more active amicus filers in the Supreme Court among public interest legal groups. We filed merits briefs in 4 cases and plan to file 2 more in granted cases. We also have 5 briefs in support of currently pending cert petitions. Our panelists today will be discussing some of those cases and petitions, along with others that have implications for free enterprise and constitutional liberties. We'll also be talking about the remarkable uptick in the activity on the so-called interim docket, emergency docket, shadow docket, whatever you'd like to call it, and that activity's impact on the justices and the lower courts. Introduce our speakers, and then we will get started with questions. Anthony Dick is a partner with Jones Day in its Washington, D.C. office. His practice focuses on constitutional, appellate, and complex civil litigation. He served as a law clerk for Associate Justice Samuel Alito of the U.S. Supreme Court and Judge Thomas Griffith of the U.S. Court of Appeals for the D.C. Circuit. Josh Patashnik is a partner with Perkins Coie in the firm's San Diego office. He recently joined the firm after serving 7 years as Deputy Solicitor General in the California Department of Justice's Office of the Solicitor General. Prior to that, Josh was an associate with the major law firm in San Francisco, a law clerk to Judge Jeffrey Sutton of the U.S. Court of Appeals for the Sixth Circuit, and a law clerk to Associate Justice Anthony Kennedy of the U.S. Supreme Court. Finally, Amit Vora is a partner with Kasowitz, LLP, in the firm's New York City office. He serves as chair of the firm's appellate and constitutional litigation practice group. He previously served as Assistant Solicitor General with the New York State Attorney General Office, as a supervising attorney and teaching fellow with Georgetown University Law Center's Appellate Courts Immersion Clinic, and as a law clerk for Judge Edward Prado of the U.S. Court of Appeals for the Fifth Circuit. I want to remind everyone that this program is being recorded, and if you have any questions for our speakers, we will get to those at the end. There's a Q&A button in the toolbar of the Zoom webinar frame that you can use. Type out your questions and send them, and then we will get to them at the end of the program. So let's start off with the court's cert grants in the 2 challenges to the president's claim of tariff authority under the International Emergency Economic Powers Act. Amit, how did these cases make it to the Supreme Court, and what specific and broader issues do they pose to the court?
Yeah, thanks, Glenn. As you know, in February, President Trump issued a series of executive orders imposing tariffs pursuant to the International Emergency Economic Powers Act, which is amusingly referred to as IEEPA. And these tariffs fall into 2 categories. The trafficking tariffs apply to goods from Canada, China, and Mexico, countries that President Trump has deemed to have taken insufficient measures to stop the flow of fentanyl into the United States. And the reciprocal tariffs, as they're called, impose tariffs ranging from 10% to 50% on products from almost all nations. Now, there are 2 separate cases on which the court has granted review. The first case was filed in the U.S. District Court for the District of Columbia, and that was filed by 2 small family-owned businesses that make educational toys and products, learning resources, and Hand to Mind. And then a second action was filed in the Court of International Trade, and that action consisted of 2 separate groups of plaintiffs. The first group was 5 small businesses, including VOS Selections, which is a New York wine importer. And the second group was a group of 12 states. Now, both the DDC and the CIT agreed with the plaintiffs that the tariffs exceeded President Trump's power. Then the DDC plaintiffs came straight to the Supreme Court asking the justices to take the case without waiting for the DC Circuit to rule. Meanwhile, the Federal Circuit, which hears appeals from the CIT, affirmed in a 7-4 majority decision. Next, the Trump administration sought review in the Supreme Court of the Federal Circuit decision, which the plaintiffs did not contest. The Supreme Court then granted cert, fast-tracked the case, and then granted cert before judgment in the DC Circuit case. So that's how we've got to where we are today. Briefing's underway. The government filed its brief on September 19th. The plaintiffs are going to be filing their briefs on October 20th, and the case will be heard on November 5th. Now, as for the issues, as always, we start with the text, right? IEPA authorizes the president to take certain actions in response to a declared national emergency arising from an unusual and extraordinary threat. Those actions include, and here's the key language, the power to regulate importation. Now, the president argues that imposing tariffs is plainly, that's the word used in the SG's brief, plainly a species of regulating importation. And therefore, IEPA authorizes the tariffs. But as the plaintiffs pointed out below, and as they're going to be pointing out in a couple of weeks, Article 1 of the Constitution provides Congress, not the president, with the power to lay and collect taxes, duties, imposts, and excises. Tariffs are taxes, and the power of the purse, including the power to tax, belongs to Congress. So given that constitutional command, when Congress in other statutes has delegated its power to impose tariffs to the president, it has done so clearly and unequivocally using terms like tariff, duty, and tax. For example, the Tariff Act of 1930, Congress empowered the president to, quote, specify and declare new or additional duties. By contrast, IEPA does not use any such terms. And if you apply the associated words canon, no scitur, and if you look at those words surrounding regulate and importation, you'll see that the president has the power to, quote, investigate, lock during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit the importation or exportation of any property. So the statute here arguably isn't clearly and unequivocally delegating to the president the congressional power to tax. Then again, SG Sauer's brief makes the compelling point that the plaintiffs are essentially advancing a magic words argument, right? And we tend to frown upon those sorts of arguments. Now, the plaintiffs, however, have a counter to that, or will be advancing a counter to that, which is that no president has used IEPA in this way since it was passed almost 50 years ago. And even IEPA's predecessor, which is the Trading with the Enemy Act, also amusingly referred with another amusing name, TWIA, that also was not used in this way. Although President Nixon had relied on similar regulate importation language in TWIA to impose tariffs, and although an appellate court, the Federal Circuit's predecessor, the CCPA, had upheld those tariffs were limited in scope, time, and amount, only 10%, unlike President Trump's tariffs. Now, the president here also has a major questions doctrine counter. So as you could discern from the argument so far, the plaintiffs will be arguing that this case poses a major question, and therefore there must be clear congressional authorization for the president's asserted power. But the SG's brief has countered that, well, the major questions doctrine doesn't apply in this foreign affairs context. Now, there's also the common sense point that's I think going to be ventilated more in the plaintiff's brief, which is that IEPA requires an emergency, and trade deficits that have existed for decades can't amount to an emergency. So there's going to be this really compelling back and forth, and it's going to be exciting to see what happens.
I mean, if you take into consideration their past writings on executive authority, power struggles between the executive and legislative branches, you have any thoughts on which justices observers should watch most carefully in the oral argument and sort of as this case goes forward?
Yeah, I think the two justices to watch are Chief Justice Roberts and Justice Kavanaugh. I mean, on the one hand, they are strong Unitarians. They believe in the unitary executive, the principle that the executive power is vested in the president alone. And that's an innovation that the framers implemented when they realized that the Articles of Confederation weren't working. They scrapped those. They realized that the nation needs an executive who can act as a chief steward to keep the ship of state afloat, as Professor Amar would say, and to protect America's interests, especially vis-a-vis foreign interests. See, for example, Chief Justice Roberts' opinion in Seal Law. See also Justice Kavanaugh's, Judge Kavanaugh's DC Circuit dissent in Free Enterprise. So those are examples of these two justices promoting the unitary executive. On the other hand, they're both also pragmatic and sensitive to business interests. For examples of that, you can see Justice Kavanaugh's dissent in medical marijuana versus Horn. And also, the best example of this is Chief Justice Roberts' compromise in Obamacare. And in this case, the U.S. Chamber of Commerce is against the president. It's tough to predict how they'll come out. In fact, Unitarians are also split. On the one hand, Professor Aditya Bamza just filed a brief on the president's behalf, an amicus brief on the president's behalf. On the other hand, Professor Stephen Galabrisi and former AG Michael Mukasey are going to be joining an amicus in support of the plaintiffs. So it's going to be really exciting to see where all the justices and where all the scholars fall in this case.
Thanks, Amit. Josh,
I would put Justice Gorsuch into that same category as well. I think he's going to be very interesting to watch in this case. There's obviously the major questions argument. There's a non-delegation argument that the challengers are making. They're the kinds of arguments that Justice Gorsuch has been very receptive to in the context of executive power, outside of the tariffs context. Now, whether, he shares that view when tariffs are at issue, I think remains to be seen. I think a lot in this case hinges on do the justices view this as a case about taxation or a case about foreign policy. But I would certainly put Justice Gorsuch in that same category to watch as well.
Anthony?
I think this is really one of the most fascinating cases of the term, not just because of the obvious stakes, but because I think it's one of the hardest to figure out where so many of the justices are going to be. The case involves some cross-cutting sort of currents that have, been prominent in the last few years. But I think, for example, the idea that we found this old statute lying around that we think authorizes government action that nobody used it for previously, right? That was a theme that a lot of the justices under the Obama and Biden administrations did not like the government to be able to do. And I think the question here is, when you have that foreign policy, foreign affairs context, whether things are different, right? And I think Justice Kavanaugh has said explicitly that the major questions doctrine does not apply in the foreign affairs context, or at least suggested as much, possibly because the president's foreign affairs powers are just more heightened and there aren't the same sort of domestic concerns that are involved. So I'm particularly interested to see how Justice Barrett weighs in on that. I think she's written a lot of interesting stuff about the major questions doctrine, and so where she is, again, it's something that I think is just going to be fascinating to see how all that shakes out. And as for once, I find myself quite uncertain where a lot of those lineups will end up.
Thanks, Anthony. So when one considers the name of the next case we're going to talk about, in the nature of at least 2/3 of the amici that support the petitioner, First Choice Women's Resource Center versus Platkin does not at first blush appear to be the kind of case we'd be discussing here in this forum. However, the other third of the 38 amicus briefs supporting petitioner include Washington Legal Foundation, the U.S. Chamber of Commerce, and the Manhattan Institute. Anthony, what kind of legal controversy would bring all these sort of groups with disparate missions together like this?
Well, I could say that the Attorney General of New Jersey has proven to have a talent for bringing people together in opposition to him, but that would be uncharitable. So I'm not going to say that. This is a case that involves a subpoena, a state subpoena of a pregnancy center, a women's pregnancy center. These types of organizations have featured prominently in some litigation in recent years. These are pro-life pregnancy centers that provide services for pregnant women, but don't provide or support abortions. And they've proven controversial, especially in blue states, and drawn the attention of regulators who have concerns about these groups' operations. So in this case, the issue is there was a state subpoena issued by the New Jersey government, the New Jersey Attorney General, and that investigatory subpoena was seeking the names of donors and donors' contact information to this organization. And so the organization filed a 1983 suit in federal court saying that this is a First Amendment violation because it is chilling the First Amendment rights of private association. Going back to some of the early NAACP cases, the Supreme Court has recognized the important interest in confidentiality and association, and that the government's ability to pry into private donors and private associations can effectively chill the ability of these First Amendment organizations to get together and pool each other's resources. So the First Amendment suit gets filed in federal court, and the Third Circuit ends up saying that this is not ripe because a subpoena, after all, could be adjudicated and enforced in state court, where First Amendment rights can be asserted as a defense against the subpoena's enforcement. So because you, Pregnancy Center, have a right to assert this First Amendment defense in a state court proceeding that would be required to enforce the subpoena, the federal courts under 1983 will not step in and vindicate your First Amendment rights in that way. So I think what's interesting about this case and why so many groups are involved is because it sort of dovetails with this recent trend where I think the court has been more and more willing to recognize that the process can be the punishment, and that making organizations go through a separate process that would be prescribed as an alternative way to vindicate their rights can really prove ineffective. I mean, it can deny them a federal forum in some cases, and just having to wait and go through that process can impose its own type of constitutional harm, because in the meantime, while you're waiting for the state courts to give you an answer, you have a very real chilling effect of people who might not want to donate money while it's uncertain whether the subpoena is going to be enforced. And there's real costs that come with that. So I think, you've seen this in some of the administrative law context where the court has been willing to say, yes, there may be an administrative process where you could, in theory, slog through a couple of years of proceedings and vindicate your rights that way, but we're not going to construe that possibility to impliedly deny your right to bring a federal suit to vindicate your constitutional rights more directly. So I think this case is likely to fit into that trend. I think the amount of support you're seeing and the fact that the court granted this case is a good sign for the petitioner.
Anthony, we'd also like to ask you about the Cox Communications versus Sony Electronics case, which really seems to be a pretty major heavyweight battle between copyright holders and the infringement issue. What issues do you think the court's going to address here, and what's at stake?
Yeah, so this is another fascinating one that reminds me a lot of a case that I had last term before the court for Smith & Wesson, which involved whether the sale of firearms generally could be deemed aiding and abetting the unlawful activity of people who use those firearms for bad purposes. The court said, no, it required a sort of tighter connection for that. So in this Cox case, it is thematically similar in that this involves an internet service provider, Cox Communications, that provides the internet service that you get when you go online. And they have been accused of contributing to copyright infringement because they know that the users that they provide internet service to are rampantly using their internet connections that Cox provides to engage in copyright infringement by downloading copyrighted works. It's no secret that a lot of people use their internet connections for that purpose, and the allegation is that Cox knows about it. So the basic question at the heart of the case is, when you provide that type of internet connection, you provide the tool that somebody's using to engage in copyright infringement. You know that that's what they're doing. Is that enough to establish this type of contributory copyright infringement? There's a second related piece to it, which involves not only whether you could be liable, but whether you could be liable for willful infringement based on your knowledge of exactly what's going on. And so the way the petition tees this up is basically to try to sort of tie in with Smith & Wesson and with an earlier case called Tomna versus Twitter, which involved terrorist groups that were using social media platforms to organize terrorist activity. And the plaintiff said, you social media platforms, that ISIS is on your network. You could do more to stop this. And so you're responsible legally for sort of aiding and abetting what they're doing on your network. And it's a similar type of idea here. the Cox knows what these infringers are doing. It's providing them this internet connection. It could be doing more to police this. They say there are steps that could easily be taken to limit this type of infringing activity. And so I think the court is likely to look at this in a similar way that it has been in sort of cutting back on these theories. Although they've got very good lawyers on the other side here for Sony, who are making some, I think, sort of copyright law specific arguments. I'm not a copyright expert, so I don't have a totally firm view on that, but I would say my expectation is that this case will sort of continue that trend of cutting back on holding people responsible for providing some general good or service just because that others may be misusing it. And what the court has said in those Smith and Wesson and Twitter and Tomna cases is you've got to actually be doing something more affirmatively involved in the wrongdoing with an actual purpose to further it, rather than making the provision of some general good or service that people misuse. So I suspect that's likely what we'll see here.
The way that the court looks at aiding and abetting also comes up in a cert petition that we'll get into a little bit later in the discussion involving the Alien Tort Statute. So definitely another theme there. So the liability exposure of government contractors arises in two cases the court has on its 2025 docket. Josh, some of your colleagues at Perkins Coie drafted an amicus brief for the chamber in one of them, the Geo Group versus Medi-Cal, which involves the appealability of a claim of derivative sovereign immunity. Can you tell us a little bit about that case?
Sure. So Geo Group arises from conditions at an privately operated immigration detention facility in Colorado. The plaintiffs in the case are individuals who are held there. There are two putative classes of plaintiffs trying to assert claims under the Federal Trafficking Victims Protection Act, the TVPA, and Colorado unjust enrichment law, regarding the conditions there and their participation in a work program that, paid them a very low wage for doing some work. It was filed in federal court in Colorado, and the defendant, Geo Group, which operated the facility, raised a defense that's often colloquially referred to as derivative sovereign immunity, which is a doctrine also sometimes called the Yearsley Doctrine, after one of the first cases to recognize it. It basically says, if you're a government contractor and the government has permissibly authorized you to do something and you performed as the government directed, that you can't be held liable. So Geo Group raised that defense. The district court rejected it, and then Geo Group sought to bring an interlocutory appeal on that issue to the 10th Circuit. And a divided panel of the 10th Circuit held that it could not be that argument could not be subject to an interlocutory appeal. The key doctrine here is called the collateral order doctrine, which generally, as many of you probably know, specifies that in certain instances, issues, although you generally need to await a final judgment before appealing, if it's an issue that promises to dispose of the case and is separate from the merits and is effectively unreviewable after final judgment, you can bring an interlocutory appeal. The 10th Circuit divided panel rejected that argument. The Geo Group sought cert, and the Supreme Court granted cert in the face of what seems to be, a somewhat entrenched circuit split on the issue. So I think this is one of those cases where you can't necessarily read too much into the cert grant, because there does seem to have been a circuit split and a need for clarification here. So the main arguments the Geo Group is making is that denials of derivative sovereign immunity are really, analytically akin to other types of immunity that can be subject to interlocutory appeals, like qualified immunity, absolute presidential immunity, sovereign immunity. It's an immunity in that sense, and that you lose the benefit of it if you're forced to stand trial. So because of that, it satisfies it's effectively unreviewable on final judgment prong. So Geo Group is arguing both that it's similar to those other immunity doctrines and that it satisfies the three prongs of the collateral order doctrine. Geo Group and its supporting amici, including the chamber and the brief that my colleagues did, have made the policy argument that the government's going to have a hard time finding contractors to do its work if they can't, rely on the availability of this doctrine and the ability to bring, an early appeal if they lose on it in the lower courts. So the plaintiffs, who are the respondents, have countered that derivative sovereign immunity, it's not appealable, both because it's not separate from the merits, which is one prong of the collateral order test, that it's intertwined with the merits issues, and also that it's not a true immunity. It's more properly viewed as just a defense to liability. And so for that reason, it is reviewable on an appeal after final judgment. You can go through a trial, and then the Court of Appeals can determine whether this doctrine should block liability against the defendant. So one thing to note about this case, I think, I probably on balance would have guessed that the petitioners were in pretty good shape, especially given the immigration detention nature of the case and just all the everything surrounding that. The U.S. government just the other day filed a very interesting brief, actually agreeing with the respondents, with the plaintiffs, that no interlocutory appeal should be available here, and really echoing their argument that derivative sovereign immunity is not a true immunity. It's just a defense to liability. And so, government contractors can't get the benefit of it in the same way that government actors get the benefit of traditional immunities. And also, really, saying that the U.S. government is not concerned about the ability of it to, about its ability to retain government contractors, that there's no reason to believe that government contractors are going to be less willing to work with the government if interlocutory appeals aren't available in this posture. So, that brief, it certainly came as somewhat of a surprise to me. It does, to some extent, take the wind out of the sails of some of the arguments that Geo Group is making. But there's certainly a case where, as reflected in the circuit split, there are strong arguments on both sides. I think it'll be interesting to see how the oral argument goes.
So the other case is Hensley versus Fluor Corporation that involves government contractors and liability. Can you give us a quick overview of that case as well?
Sure. Yeah, that's a case. It's really a follow-on to a 1988 decision called Boyle versus United Technologies Corporation. The issue is under what circumstances federal law preempts state tort claims brought by service members against government contractors for injuries sustained in the course of their service. So the facts of this case are unfortunate. The plaintiff was the U.S. Army specialist, was stationed at Bagram Air Base in Afghanistan, and was seriously injured in 2016 when a suicide bomber detonated a vest inside the airbase. The defendant is Fluor Corporation, which had a contract from the Defense Department to provide logistical support, food service, that kind of thing at Bagram Air Base. And in the course of doing that, employed Afghans to work there, and was supposed to go through certain screening and security protocols, which it's alleged that Fluor neglected to follow. The plaintiff filed suit in federal court in South Carolina, alleging essentially negligence claims, some other things, but basically a state law negligence claim. The district court and the Fourth Circuit both held that federal law preempted that claim, extending. So Boyle, the case I mentioned, involved a claim brought by, I think, a Marine pilot who had died in a helicopter crash against the manufacturer of the helicopter for a design defect. And by a 5-4 vote, the Supreme Court held that although there's no statute that squarely preempts that kind of claim, that federal common law, sort of as a general matter, preempted it. So that the lower courts in this case extended that doctrine to hold that federal law also preempts the kind of tort claim that the plaintiff seeks to bring here. The court granted cert, and the petitioner is the plaintiff, the injured service member. He essentially makes two separate arguments. One is that Boyle, he doesn't squarely argue that Boyle should be overturned, but argues at least that it should be limited to its facts, that it finds no textual support in the Federal Tort Claims Act or any other statute, and that it is an outlier in terms of how the court generally looks at preemption. But then he also argues that even if Boyle remains good law, this case is distinguishable because in Boyle, the helicopter manufacturer followed the DoD's specifications, whereas here, there's an allegation that the contractor did not abide by its contractual commitments. So that's an arguable point of distinction. I think ultimately, though, this case is really about what the court thinks of Boyle. Boyle is a controversial decision. So I never interviewed with Justice Scalia. He was the author of the opinion, but I had friends who did, and it was sort of widely known that one question you sometimes got at the Scalia interview was, what's one of my opinions that you disagree with? And there was sort of a set of answers that were considered, good or acceptable answers to that question. And Boyle was near the top of that list, because it is somewhat in tension with general principles of textualism and originalism in terms of how you think about preemption. And so it'll be interesting to see, where this court is on Boyle, whether, again, it's not the plaintiff isn't asking for it to be overruled, but maybe limited to its facts, and at the very least not extended to the situation where there's an allegation that the contractor failed to abide by, failed to do what it was supposed to do. So it'll be interesting to see how this case pans out.
Anthony, Amit, any thoughts on either Hensley or the Geo Group case?
I think Josh captured it perfectly and exhaustively.
Okay. All right, we'll stick with Josh for another minute or so, a few minutes. The court also has on its docket 3 cases where the questions presented involve not the merits of the case, but the issue of removing causes of action from state to federal court. Josh, can you explain this sort of larger concept of removal, why it's important to the business community, especially when they're on the right side of the V, and then talk about the cases themselves kind of briefly?
Sure. So as I'm sure many of you know, removal is a general concept where if you're the defendant and a case is filed in state court, you can remove it, that is, move it over to federal court if it could have been filed in federal court in the first instance. That is, if there's federal subject matter jurisdiction, either because there's federal question jurisdiction, that the one or more of the claims arises under federal law, or if there's diversity jurisdiction, complete diversity between the parties on both sides of the V. And, as Glenn suggested, business interests in particular would often rather be in federal court because there is a perception, sometimes an accurate perception, that state courts are more plaintiff friendly and more hostile to large, out-of-state corporate defendants. And there's certainly a flavor of that in at least one of these cases. So the 3 cases, I'll just go through briefly. One is called Haines Celestial v. Palmquist. This is a case where parents of a young child sued the maker of Earth's Best organic baby food, as well as Whole Foods, which is where they bought the product in Texas state court for the harm that the product that allegedly caused their child. At the time it was filed, there was not complete diversity because both the plaintiffs and Whole Foods are citizens of Texas. The district court, or the defendant, sought to remove. The district court dismissed Whole Foods as a party, and at that point there was complete diversity, and so the case proceeded to judgment, went up to the Fifth Circuit. Fifth Circuit said, Whole Foods shouldn't have been dismissed, so there wasn't complete diversity. And the question is, what do you do in this situation where there's an erroneous dismissal of a party that leads to there being complete diversity at the time of judgment, but in a way that was incorrect? This is an instance where there's a circuit split on this issue. There just needs to be a clear question, a clear rule, one way or the other, of what happens in this circumstance, where there's a mistaken dismissal of a party that leads to complete diversity that would otherwise have been lacking, and the case would have had to go back to state court. The second case is a case called Chevron USA v. Plaquemines Parish. This is a lawsuit brought by some local governments in Louisiana alleging environmental harms stemming from oil production activities stretching back decades. So a big, massive case, closely watched, and a case where I think it's plausible to think that the local courts might be, somewhat unfriendly for the defendant, Chevron. Chevron sought to remove to federal court on the basis of the federal officer removal statute, 28 U.S.C. 1442A1, which generally says you can remove if the activities of the suit involved you acting under an officer of the United States for or relating to, and this is new language that was recently added in 2011, for or relating to any act under color of such office. Chevron argues that at the very least, the claims here relate to its oil production activities during World War II, which were directed by the federal government pursuant to contracts with the federal government. A divided panel of the Fifth Circuit held that removal was not appropriate. The case should go back to state court because the allegations here don't meet that relating to standard, that they involve activities pertaining to oil production, but Chevron's contracts with the federal government involved oil refining, and so that production and refining are distinct, and that the plaintiffs aren't seeking to hold Chevron liable for that. So that'll be a case, one of the first cases to really spell out how courts should apply this new language in the federal officer removal statute. The last case I'll just briefly touch on is a case called Enbridge Energy versus Nestle. This is another case involving energy production or transport. Enbridge owns a pipeline, runs between Michigan's upper and lower peninsulas. The Michigan AG sued Enbridge in state court to enjoin the continued operation of the pipeline based on alleged violations of Michigan law. Enbridge sought to remove the case, but did so 2 years after the general 30-day deadline to remove to federal court that the statute sets forth. And the issue in this case is whether district courts, whether that statute is subject to equitable tolling, basically, whether district courts can excuse removing defendants' failure to comply with that 30-day deadline. The unanimous panel of the Sixth Circuit, and actually a fairly conservative panel of the Sixth Circuit, held that the statute is not jurisdictional, but it is a mandatory claims processing rule, so that the district court had no authority. Once the Michigan AG objected to the removal, district court had no authority to excuse the late removal. So just summing up, what can we infer by the fact that the court has granted these 3 cases? Sometimes you don't want to read too much into the fact that they have multiple cases in a single term dealing with an issue. Sometimes it's a coincidence. Here, I would say there does seem to be a pattern. These are all cases in which the petitioner is the party that sought to remove, and the lower courts rejected the removal argument. It could reflect some view on the part of at least some justices that federal courts are not being sufficiently sensitive to the arguments and interests advanced by removing defendants. And I would particularly note in the Enbridge case, the other 2 cases, I'm not that surprised that cert was granted. There was a circuit split in Haines Celestial, Chevron v. Plaquemines Parish. I mean, that case has the flavor of a Supreme Court case, major environmental case involving, oil production in the Gulf of Mexico. Enbridge, its arguments for why it didn't remove the case earlier are not particularly compelling, at least to me when I read the briefing. There wasn't really a strong circuit split. So that case, certainly not a slam dunk grant. And the fact that the court granted it, to me, you could read into that they really are at least somewhat interested in these removal issues. And so we'll see what ends up happening with those cases this term.
Thanks, Josh. That sort of gets us through most of the granted cases, at least the ones that are of most interest to WLF and its mission. The court's obviously going to be granting quite a few more cert petitions after its so-called long conference that's happening after our program, unfortunately. So let's take a few minutes to talk about this pending cert petitions that are relevant here. There's 2 petitions that WLF supported with amicus briefs where the court has invited the Solicitor General to offer the government's views: Monsanto Company versus Darnell and Cisco Systems versus Doe, which I sort of referenced earlier when we were talking about aiding and abetting. Anthony, can you talk about those 2 petitions and whether you think the Solicitor General will recommend review?
Sure, happy to. I think that after reviewing the papers, it seems likely to me that the Solicitor General will and should recommend review in both. It's a little hazardous always to guess what the SG's office is going to do. I think this SG's office tends to share the view of many members of the Supreme Court bar that the court should be taking more cases to provide some more clarity in the law, but the jury's still out a little bit on that. I think this long conference and this forthcoming term will tell us a lot about that. So let me take these in order, and it'll be quick because I know we have a few more to get through and we want to get to questions. But the Monsanto case involves everybody's favorite federal statute, the Federal Insecticide, Fungicide, and Rodenticide Act, which, as we all know, the framers of Article 1 were very concerned about Congress regulating the killing of rodents. This case does not involve rodenticide. It involves Roundup, which is a weed killer. I guess you might try to use it for killing rodents, but I wouldn't recommend it. So the issue in this case is a preemption. FIFRA, as the statute is known, has an express preemption clause for labeling of pesticides. So Roundup, the pesticide at issue here, there's a claim that, lots of cases have claims that Roundup causes cancer, but FIFRA requires an FDA labeling approval process where the FDA considers different types of warnings and decides what kind of warnings should be on the label of a product. And, there's a lot of back and forth with the companies, and then they consider a lot and they approve a particular label for the product. And then there are these state law failure to warn claims that a lot of plaintiffs bring, saying, you should have warned me your product was going to cause cancer. The FDA considered that type of warning and said not to put that on this particular product because it didn't think the science supported it. And so this express preemption clause says state law can't require labeling that is additional or different to what is required under federal law. And a circuit split has now developed on when the FDA has decided what the label should be and a state law failure to warn claim is brought, does that fall within the scope of that federal express preemption clause? It's interesting in its own right. There's a lot of these labeling preemption cases all over the place, and they're very important because these cases tend to be high dollar cases. But it's also, I think, interesting to look at through the lens of recent Chevron developments and changes in administrative law, with the court being less willing to give legal effect to some agency decisions with respect to what federal law might mean or require. And so that plays into this case. This is, it's often thought that industry tends to be more favorable of giving less deference to agencies, but in this case, the agency action is a basis for preemption of a lot of very expensive tort claims. So that's just an interesting dynamic to see how that unfolds. I think the circuit split that has developed there makes it likely that this case will get granted, but we'll see what the SG has to say. So the other case you mentioned, Cisco. This is a case involving our old friend, the Alien Tort Statute, that's been with us since 1789 in the Judiciary Act. It was for a long time dormant, and you didn't see much action under it. But it was, in the last few decades, sort of picked up on by some plaintiffs' lawyers who started to use it to bring claims involving sort of alleged human rights violations overseas. Again, a lot of very big dollar claims. And in recent years, the Supreme Court has sort of been granting these cases on a somewhat regular basis to sort of clamp down on this type of liability. So this case involves Cisco, the technology company, selling network equipment to Chinese government agencies that were alleged to be using those technology components that were sold by Cisco to commit human rights violations against members of the Falun Gong sect in China, allegedly in violation of human rights and international law. And so the reason this ties into your aiding and abetting comments from before, Glenn, is because it's an aiding and abetting claim that basically Cisco knew that it was selling these products to China, even though federal law allowed the sale of these products to China. It knew that China was, misusing them to engage in human rights violations, therefore should be held liable for aiding and abetting. So the main question presented in this case is whether the Alien Tort Statute allows for an implied cause of action for aiding and abetting, which is always the question under the sort of federal common law backdrop. What types of claims are available to be brought under the Alien Tort Statute? The statute was originally passed for a fairly narrow purpose of providing claims for ambassadors, claims about rights of safe passage and piracy and things like that. So the question is whether you have this implied right of action for aiding and abetting of this type of violation overseas. I think it's quite likely that if the court granted this case, it would say no to that. The court's been very skeptical of creating these type of implied rights of action. So I think there is a colorable split here. So we'll see what the SG has to say. But this is another one that I think looks pretty good for the petitioner.
So, Anthony, the Monsanto company case that comes from the Missouri Supreme Court, does that have any impact, you think, on whether or not the court's going to take it, or what the SG's office might be recommendation? There's been other cases involving Roundup that have gotten up to the Supreme Court that have come from circuit courts, federal courts, and they haven't taken those. So it's just interesting to me that this is a state decision. And how might that play in?
To me, that doesn't weigh hugely either way. And I think what's important is the recent emergence of a Third Circuit opinion that recognized this split, which I think gives a lot of credibility to it. And so to me, that's not a major downside for the court in taking this.
The question of whether state governmental entities must respect the rights provided to the Seventh Amendment to the U.S. Constitution is at issue in the petition in Thomas versus Humboldt, since this is an issue that interests you quite a bit. Amit, can you tell us more about this petition?
Yeah. So as we know, the Seventh Amendment guarantees a right to a civil jury in cases that are legal in nature as opposed to equitable. And the Supreme Court recently clarified the scope of the Seventh Amendment in Jarkissi. But non-lawyers and lawyers alike are sometimes surprised to learn that the Seventh Amendment still hasn't been incorporated against the states. It's the last important remaining provision of the Bill of Rights that doesn't apply to the states. And this petition presents the court with the question of whether it should be. Now, there is Supreme Court precedent saying that it shouldn't be. This case is Bombolas from 1916. But at that time, incorporation was a quote, new and strange concept. That's actually the terminology that the court used then. And since then, the court has come around to incorporation in the past decades, has selectively incorporated the provisions of the Bill of Rights. In Heller, for example, incorporated the Second Amendment against the states. And now we'll see if the Supreme Court will incorporate the Seventh Amendment. And in this particular case, it actually highlights sort of the injustice that can follow when state agencies are not required to prove their claims to a jury. So in Humboldt, the respondent, which was actually Humboldt County, imposed a $7.5 million fine on one of the petitioners and a $1.8 million fine on another petitioner for code violations related to cannabis on their properties, even though their properties never had any cannabis. And these petitioners were not wealthy individuals, and these fines were ruinous. And yet, rather than having to prove its claims to a jury, the county channeled its claims through a code enforcement regime under which, unsurprisingly, the county never loses. So you can already tell that the arguments here are going to echo the arguments that were made in Jarkissi. And another feature of this petition that's interesting is the timing. In Heller, you remember, the court took that case, in McDonald, the court took that case a couple of years after Heller. So in Heller, the Supreme Court held that the Second Amendment right is an individual right. And after defining sort of the nature and the contour of the Second Amendment right, the court took up whether the Second Amendment should be incorporated against the states. And the thinking is that the court did that so that the Second Amendment right could develop uniformly and coherently, so the doctrine could develop coherently both in the federal and the state context. Similarly here, the thinking is that the court might be tempted to grant cert so that the Seventh Amendment right can develop coherently and uniformly in both the federal and the state context. So we'll see what happens in a few days.
Josh, any cert petitions you'd like to highlight?
Yeah, one that I would flag is a cert petition filed by Canon Shanmugam and his colleagues at Paul Weiss in Suncor Energy v. Boulder County. This is a case about whether the either federal common law or the Clean Air Act preempt state law claims seeking to hold energy companies liable for harms associated with climate change. As some of you may remember, there have been a slew of cases, including a U.S. Supreme Court decision regarding whether these claims can be removed from state court to federal court. There's a variety of these claims that have been brought in state courts across the country. The defendants have almost universally sought to remove them to federal court. They have generally been unsuccessful in that effort, although there's been a lot of litigation surrounding that. In this case involving Boulder County, the removal effort was unsuccessful, so it went through, at least at the initial pleading stage, went through in state court up to the Colorado Supreme Court, which held by a divided vote that these claims could proceed, at least to discovery. And so Suncor Energy is now seeking Supreme Court review on the merits of the claim that federal common law and the Clean Air Act preempt these state law tort lawsuits associated with climate change. This is, I think, one of the first petitions, not about removal, but about the merits of this preemption argument to reach the court. The U.S. And a variety of other business groups have filed amicus briefs in support of the cert petition, so it's certainly one that the justices are going to look closely at. I would not be at all surprised to see a cert grant in this case, although it's also possible there are some arguments that there's either jurisdiction or vehicle problems, just because it's still a very, case is still at a very early stage. It's really an interlocutory decision of the Colorado Supreme Court. So there could be discovery and a trial, but the Supreme Court might also think that it wants to address this at the outset, whether these preemption arguments have validity. So certainly a petition to watch in the coming weeks.
Thanks, Josh. So WLF's been doing these programs for over 30 years, and I can't ever remember anyone before me or me saying this, but we can't have a briefing about the Supreme Court term without a mention of the interim docket, as the SCOTUS blog calls it. Justice Kavanaugh's called it that. It's also known as the emergency docket, as I said at the outset. Some still call it the shadow docket. So 2 questions for you, Amit, on that, and we certainly welcome the other panelists' view on that. First, Do these interim decisions have precedential value, either for lower federal courts or the Supreme Court itself?
I think they do have precedential value for lower courts, not for the Supreme Court itself, because the Supreme Court can do what it wants when it gets a case. But the required reading on this is Justice Gorsuch's partial concurrence and partial dissent in NIH versus American Public Health Association. There, the court 5-4 agreed to allow NIH to terminate 783 million grants linked to DEI initiatives. Now, here's the key language from Justice Gorsuch. Of course, decisions regarding interim relief are not necessarily conclusive as to the merits because further litigation may follow. But regardless of a decision's procedural posture, its reasoning carries precedential weight in future cases. Goes on to say, moreover, even probabilistic holdings must inform how a lower court proceeds in like cases. All right, so what does that mean? Let's take Wilcox. In Wilcox, the court issued an interim ruling which stayed a district court order enjoining the president from removing an NLRB member and an MSPB member because the statutory restriction on the president's power to remove them likely violated Article 2. All right, so given that holding, even though it was presented in probabilistic terms, the language is, we do not ultimately decide in this posture whether the NLRB or MSPB falls within such a recognized exception. That question is better left for resolution after full briefing and argument. So even though it's a probabilistic holding, under Gorsuch's reasoning, his point is really that the district court in Boyle, which concerned the statutory restriction on the president's power to remove a CPSC commissioner, that court shouldn't have so easily reinstated the commissioner because it should have felt bound by Wilcox. So to Slaughter, that concerned the statutory restriction on the president's power to remove an FTC commissioner. There, the district court shouldn't have been so quick to reinstate the commissioner. Now, there are strong counterarguments, though. As Professor Stephen Vladeck points out, Wilcox itself had an exception to its reasoning. And this is an exception that's going to be of interest to everyone here, including WLF. In Wilcox, the court said its reasoning did not apply to the Federal Reserve Board, which is a uniquely structured quasi-private entity with a distinct historical tradition. But that carve-out arguably invites other carve-outs. So is it really an act of defiance when the district courts in Boyle and Slaughter reviewed the Supreme Court's ruling in Wilcox, when they read it and said, you know what, this interim ruling doesn't bind me? And there's also an argument that Justice Kagan has recently explained in public remarks, which is that writing out the reasons for a decision serves important adjudicatory values. When she says courts are supposed to explain things. And what she means by that is reason giving makes a decision's holding comprehensible. It enables lower courts to abide by the decision. It confers legitimacy on the decision. I'll also add that writing out the reasons for a decision improves the quality of the decision. There's the empirical evidence that human cognition isn't necessarily truth tropic, and we have all sorts of tools to improve the quality of our reasoning, the scientific method, intellectual humility. Another tool is writing. And I think we've all experienced the phenomenon of writing something out and realizing how it crystallizes our reasoning. But in these interim orders, which don't have much reasoning, you don't have that. You're not forced to justify your outcome, and you're not forced. The discipline of writing out those reasons arguably improves the quality of the decision. By contrast, Justice Kavanaugh, in public remarks, has recently warned against the lock-in effect of spelling out reasons without full briefing and argument. And that's a good point, too. And this is a point that Professor Schauer, the late Professor Schauer from the University of Virginia, explained in his Giving Reasons article in the Stanford Law Review, which is an excellent article that really gets into the pros and cons of giving reasons. So yeah, it's a fascinating topic. Now we see that the shadow docket is being increasingly invoked, and I think that partly might be due to aggressive executive action. It's also in part because we have a court where a majority of the justices now take separation of powers issues really seriously. And that might not have always been the case, but they view these injuries as causing irreparable harm and worthy of preliminary injunctive relief. So if a president fires an agency head or commissioner and a district court reinstates that individual, our Supreme Court will weigh in because that's an affront to Article 2 that we can't just leave unremedied.
Anthony?
I think on the opinion rating point, there's also the practical point that I think sometimes gets overlooked, which is that, the need to issue written and reasoned opinions has an impact on how much bandwidth the court has to police the lower courts, just because as a practical matter, it takes a lot more resources. And when you're going to write out a full opinion, you're able to, I think, act in fewer cases because you don't have the ability and the personnel as a court to be taking that many cases, especially when they're flying fast and thick on the ground, where you need to do a bunch of things to police the lower courts. So I think some of the criticisms and defenses of what the court does on the interim docket are influenced by where people stand in terms of whether they want to see the court doing more or doing less to police what lower courts are doing. And depending on your perspective, it's either the lower courts are out of control and the Supreme Court needs to be doing more to police them, or the Supreme Court's getting involved too much. But I think that's an important part of the dynamic that sometimes gets overlooked.
Josh?
Yeah, I'll just add, I thought it was a little bit puzzling to see that Justice Gorsuch opinion in NIH in particular, because there were arguments in that case that the issues there were distinguishable from the issues in earlier Supreme Court emergency docket cases, in particular the Department of Education versus California case, which I worked on in my last job at Cal DOJ. And there, in NIH, there were, so it ended up being a 4-4-1 split. The three liberals and the chief would have not granted emergency relief. Justice Barrett would have granted it in part, not as to the grant terminations, but as to the policy. And then the other four justices wouldn't have granted any relief. So there were real questions in that case about whether the issues were distinguishable. And so it didn't seem to be a great instance of lower courts just ignoring Supreme Court emergency docket decisions. There might be other examples of that. I think maybe the removal of firing of federal officers might be a better example of that. But so I was a little bit puzzled to see that opinion from Justice Gorsuch in that particular case. But we will see what continues to happen on the emergency docket, especially with the Lisa Cook case currently pending there.
You mentioned the Slaughter case and the Wilcox case. Can you mention, for those who may not be familiar with what's happened recently in those cases, sort of where those have gone and how does the role of the interim/emergency docket play into what the court did the other day in terms of granting and declining certain cases?
Yeah, so in Slaughter, the district court, as I mentioned, reinstated the commissioner, and that was appealed to the DC Circuit, but the Supreme Court is now granted cert before judgment. So it's going to take that case on, and it did deny cert before judgment in Wilcox and Boyle, but the thinking is that the Supreme Court's decision in Slaughter is going to provide the reasoning that should apply to the other agencies. Now, we'll see the extent to which it does. It'll depend on what the Supreme Court actually says, because the FTC might have unique issues that don't apply to the NLRB and the CPSC and other agencies. But Slaughter in particular puts a case called Humphrey's Executor on the chopping block. There, in Humphrey's Executor, that the Supreme Court said that the FTC, as it was designed then, the commissioners there did have protections from the president's Article 2 power to remove them. But that FTC, according to the Supreme Court at the time, was a quasi-legislative, quasi-adjudicatory body that didn't wield executive power. Our current FTC, though, absolutely does wield executive power. So arguably Humphrey's executor no longer applies and will be overruled, but we'll see what happens.
So one final question for either Anthony or Josh. Amit mentioned that they granted the Slaughter case on the cert before judgment. They did the same thing in the cases involving the tariffs as well. Can you explain that for those who may not be familiar with that concept? And do you think that's going to become a more common act by the Supreme Court because of this sort of flood the zone with very important separation of powers issues that end up on the interim docket initially, but then that go back into the court pretty quickly?
Yeah, so what the statute says is that once a case is in the Court of Appeals, it's fair game for the Supreme Court to grant cert. So any party, once a case, you can't do it just when a case is in the district court. It has to be in the Court of Appeals. But once an appeal has been filed, any party can file a cert petition asking the court to grant cert before judgment. It's very, very rare historically for that to happen. There are all sorts of reasons why it's not typically a great practice. The tariffs case, I think it's a clear instance. I'm not at all surprised the court did it there. This is a really, major question of law that we need a fast resolution to. And so that case is sort of a poster child for it. The Humphreys executor cases, I think historically you would expect if an administration wanted a longstanding precedent to be overturned, they would be content to live with it during the 1 or 2 years it would take for a case to get up there in the ordinary course. This administration is not happy, would not be satisfied to do that. And the court, whether surprising or not, has indulged them and has said, okay, we're going to, effectively overrule Humphrey's executor on the emergency docket. Given that, and given, that in the interim, the officers have been removed, there's no real reason to wait, I guess. It does make sense just to have them do it and overrule Humphrey's executor, which they're clearly going to do, and be done with it. So I would not be surprised to see it used more often going forward as a mechanism.
Yeah,
Anthony, thoughts on that?
Yeah, I'll add, I think it's probably influenced by the courts being inundated with all the emergency applications, and it wants to put a stop to that and get a quicker resolution. And there's also, I think, the interesting question of whether the court ends up formally saying it's overruling Humphrey's executor or just we're reading Humphrey's executor according to what it originally said, which is that it didn't apply to agencies that actually exercise executive power, and then taking that principle seriously so that it would effectively just not apply to any agencies anymore. So that may be, in practice, a distinction without a difference, but I think it matters from a stare decisis standpoint of whether the court says formally this opinion is no longer good law, or just that this opinion doesn't actually apply to any agencies in the real world.
Amit, any final thoughts on that?
No, I think they captured it perfectly.
I see that we are now at our witching hour of around 2 o'clock, and all of the things that you all said were so clear that our audience doesn't have any questions. So congratulations on that. Thank you, everyone, for joining us today, and thank you to our speakers for taking the time out of their very busy schedules to get ready for this program and to spend the hour with everyone here. If you have a moment when you log off, there'll be a 5-question survey. If you just click on that and do that, that's extremely helpful for us to know whether we're doing a good job with these programs and targeting them correctly. And again, hope everyone enjoys the upcoming term. Have a good day.
Thank you all.